Mark Lazon Casterman, you are a murderer. You my sister.
I'm trying to understand why you think my mom and family deserved your brutality. I don't believe you're a murderer, just a cold-blooded killer.
I'm under arrest, okay? You got me?
On November 21st, 2022, a heartbreaking tragedy unfolded in Milwaukee when Noah Mentate fatally shot his mother, Quiana Mann, inside their home on 87th and Hemlock. According to investigators, the boy was upset after his mother refused to buy him a virtual reality headset. After retrieving a secured weapon, he allegedly fired it, striking her fatally. He later used her account to purchase the headset himself. The boy initially claimed the shooting was accidental, but later admitted he had intentionally. Family members had raised concerns about his behavioral issues prior to the incident. In the months that followed, the case drew national attention. Due to the seriousness of the offense, prosecutors charged the boy as an adult. His defense team challenged his mental competency, prompting a psychological evaluation.
It's my understanding that there is a competency challenge. Attorney Cunningham.
That is correct. There's concern that may not understand what's going on and is not able to assist in his defense. So we are asking the court for a competency evaluation.
Dr. Gus Bry is going to come and talk to you at detention. So she's going to ask you a bunch of questions and go over a bunch of things with you. So she's very nice. You will like her.
By mid-2023, doctors found him competent to stand trial. Defense attorneys had sought to move the case to juvenile court, arguing his age and capacity warranted it. But on Monday, a judge ruled that the case will remain in adult court. Mentate is charged with first-degree intentional homicide and faces up to 60 years in prison if convicted. On May 6, 1979, 38-year-old Donna Mae Byerl vanished from her Muskego, Wisconsin home after what her husband, John Byerl, described as an argument. He claimed she walked out and never returned. Despite initial beliefs that she might have left voluntarily, years passed without any contact or trace of her. Suspicion eventually fell on John, who was always considered a person of interest. Over time, evidence began to surface, including spatter in the garage later matched to Donna's DNA, and investigators reclassified her disappearance as a homicide.
You accused him.
Yes, I did. My Donna Mae would not have ever left her girls. Never.
Testimony from Donna's sister and daughters revealed a troubling pattern of domestic conflict, including recollections of past abuse.
It was in the front room, and my mom was kind of crouching down between the couch and the end table, and my dad kind of standing over her with a bottle.
Well, the first time you told the police was March of 2016.
I can swear to God I did.
In 2009, one of the daughters recorded John admitting to an extramarital affair around the time of Donna's disappearance.
I know that you were seeing somebody else.
I'm sorry. It's kind of late now to say that, but I'm sorry.
4 decades after Donna's disappearance, John Byerl was arrested in Florida in 2019 and charged with first-degree intentional homicide. His trial began in June 2019, where prosecutors relied heavily on circumstantial and forensic evidence. Although Donna's body was never found, the jury was convinced beyond a reasonable doubt. On June 26, 2019, John Byerl was convicted, and 2 months later, he was sentenced to life in prison with no parole eligibility for 35 years. Throughout the proceedings, Byerl maintained his innocence and refused to reveal what happened to Donna, leaving her family without full closure. In March 2019, Sierra Robinson traveled from Las Vegas to Milwaukee, hoping to pick up her daughter, Noelani, from her ex-boyfriend, Darius Higgins. Instead of a peaceful reunion, Higgins misled Sierra and her friend Wanisha Parker, leading them across the city under false pretenses. Eventually, a confrontation occurred, during which Sierra tragically lost her life, and Wanisha was seriously injured. An Amber Alert was issued for little Noelani. Sadly, her body was discovered days later in a rural area in Minnesota, wrapped in a blanket.
As many times as I wanted to give up, y'all, I wanted to give up so bad.
Man, I wanted to give up, and I couldn't give up because of Nolani and Sierra.
More than 2 years later, on July 26, 2021, a Milwaukee judge sentenced Higgins to life in prison without the possibility of parole, plus 10 additional years for Parker's injuries. The judge was especially disturbed by Higgins' lack of remorse, as he chose to blame the victims during sentencing.
I did not know that it was going to end up turning out the way that it did, but Sierra took something from me, and she tried to use the as a bargaining chip.
Quite frankly, it would have been to your benefit to probably say nothing.
In April 2024, in Minnesota, Higgins also pleaded guilty to a second-degree murder charge in connection with Nolani's death. He received a 17.5-year sentence, which will run concurrently with his Wisconsin term. In September 2023, Melissa Casterman Madako was killed along US 31 in Mason County, Michigan. According to authorities, she had exited the vehicle after an argument with her husband, Mark Casterman. Witnesses and investigators reported that Mark drove past her twice before making a U-turn and striking her with the car. Surveillance footage from a nearby casino showed that Mark had a blood alcohol level of 0.209, while Melissa had none in her system. The prosecution argued that the act was deliberate, citing Mark's erratic behavior and history, while the defense maintained it was an alcohol-influenced accident.
But I can indicate that this was not just an OUIL causing, as was argued vigorously by the defense, and the plea was made for a plea to that charge. This was, in fact, a homicide.
On May 2, 2025, Mark Casterman entered a no-contest plea to second-degree murder. During sentencing on June 17th, emotional statements were made by Melissa's mother and sister, calling him selfish and blaming him for the loss.
Mark Lazon Casterman, you are a you my sister.
It's not going to bring my daughter back.
You're a selfish individual, Mark. But it's okay. It's okay. All your choices. You are free to choose, but you are not free from the consequence.
Mark tearfully addressed the court, denying intent to harm.
And I'm sorry that this happened, and I never ever intentionally tried to do none of this.
The judge, acknowledging the irreversible damage caused, sentenced him to 15 to 50 years in prison. While the legal process has concluded, the emotional impact on both families remains deep and unresolved. In April 2017, Sean Clemens broke into the Liberty Township, Ohio, home of his elderly neighbor, 84-year-old Jane LaRue Brown. During the break-in, Clemens harmed Brown and stole items from her house before leaving the scene. Brown was later found in her home, and the incident shocked the local community. After his arrest, Clemens was charged with aggravated murder and other related crimes.
I'm trying to understand why you think my mom and family deserved your brutality. I don't believe you're a murderer, just a cold-blooded killer.
Some have called him a monster. I've never used that word. I don't have a word to describe him.
In court, Brown's family shared how deeply her loss affected them and how they struggled to understand Clemens's actions.
We felt that there was a chance that we could lose some evidence in this case, given some of the legal background, given his lack of a violent criminal record. We felt that it would be hard-pressed to get the penalty at this point. The victims were agreeable to it, and we just felt that it was the right time, and it really worked out in terms of he got a life sentence.
On count 2, aggravated murder, you will receive a life imprisonment sentence without the possibility of parole.
We're relieved, and I think the victims are relieved that now they can have closure from coming to court, worrying about appeals, worrying about what may happen down the road, and knowing full well that this defendant will spend the rest of his natural life in prison.
Clemens first pleaded not guilty, but later agreed to a plea deal in 2018 to avoid a possible death sentence. The judge sentenced Clemens to life in prison with no chance for parole, ensuring he will spend the rest of his life behind bars. In October 2023, Ahmed Alid, a 45-year-old Moroccan man living in Hartlepool, England, carried out an attack motivated by anger over the tension in the Middle East. Early on the morning of October 15th, he first went into his housemate Javed Nouri's room and seriously injured him. Alid then left the house and encountered Terrence Carney, a 70-year-old man who was out for his morning walk. Alid attacked Carney, who sadly did not survive. Security cameras and witnesses helped police quickly locate and arrest Alid, who also later caused a disturbance while in custody.
All right.
Open the doors, please.
At his trial in Teesside Crown Court, prosecutors described the act as an attempt to spread fear in the community for political reasons. Alid was found guilty of murder, attempted murder, and assaulting police officers during his arrest.
Stand up, Ahmed Ali Alid. On the 15th of October last year, you attacked and murdered Terrence Carney in a terrorist act. You hoped to frighten the people of Britain and to undermine the freedoms they enjoy. For each of these offences, you are sentenced to life imprisonment. For attempted murder, the minimum term is 19 years, 52 days. This will be served concurrent to the sentence for murder. The minimum term for murder, of which you must serve every day, is 44 years and 52 days. After that time has passed, the parole board will be able to decide whether you can be released. It is possible that you will not be released even then. Given the sentences I've passed, there will be no separate penalty for the 2 charges of assaulting an emergency worker in the execution of her duty. Finally, I impose the statutory surcharge in the appropriate amount. Please take him down.
In May 2024, the judge sentenced him to life in prison with a minimum of 45 years to serve before he can even be considered for release. The court made clear that Alid's actions were driven by hate and aimed at intimidating the public. In June 2025, Gabriela Muniz and her partner Victor Gonzalez were arrested after their son was found unresponsive following a nap at their Albuquerque home. The couple admitted to co-sleeping with the boy and being frequent drug users. Prosecutors charged both with child abuse resulting in death, noting that the boy had previously tested positive for fentanyl and meth at birth. Despite a state-issued safety plan meant to protect the boy remained in their care. At the time of arrest, the cause of death had not yet been determined, though authorities suspected it was linked to neglect and unsafe conditions. Muniz appeared emotional in court, while Gonzalez also faced similar charges in a separate hearing.
Advocate for my son.
While in jail awaiting trial, Muniz faced new charges after allegedly bringing powdered fentanyl into the facility, which caused another inmate to overdose. She admitted to possessing the drug and handing it over to officers after the medical incident.
I will also let the court know that the defendant was arrested on new charges yesterday in MDC. The defendant did admit that she did have the fentanyl on her. She admitted that it was pure powdered fentanyl. And it was confiscated from her. She poses a danger, unfortunately, to the other inmates in MDC, as indicated by these new charges and the fact that she brought fentanyl in to what was supposed to be a dry cell.
Prosecutors emphasized the continued risk she posed, even while behind bars, and argued for her continued detention.
The nature of it is tragic. However, not every tragedy is a crime. At this point, we do not have an autopsy. We have no idea how this child died. This child could have died of SIDS.
The defense claimed the boy might have died of natural causes and asked for her release. However, the judge denied bond, citing the serious nature of the charges and the danger posed to others. Muniz now awaits trial on both child abuse and drug-related charges. On the evening of March 23, 2024, Delia Sims was shot near her home on South Ridgewood Avenue in Tacoma. According to police, Delia had recently broken up with her boyfriend, Aiden Tyrrell, but the two were still in contact. Court documents say Tyrrell had already fired shots at her home a day before the incident. That Saturday evening, Delia stepped outside during a phone call with her sister and was shortly after. She was taken to the hospital but did not survive. A few days later, on March 26th, Tyrrell turned himself into police and was arrested. He was charged with first-degree murder, first-degree assault, drive-by shooting, and unlawful possession of a firearm. He appeared in court on March 27th, where he pleaded not guilty. The judge set his bail at $3 million while the investigation continues. In 2010, Hemi Newman was living in Georgia, working as a project manager at GE Energy. His marriage was falling apart, and at the same time, he was spending a great deal of time with a co-worker, Andrea Snyderman. Friends and prosecutors later suggested that this closeness became more than just professional. On the morning of November 18th, 2010, tragedy struck. Rusty Snyderman, Andrea's husband, had just dropped off his son at daycare. Moments later, he was attacked in the parking lot and collapsed near his car. He did not survive. Investigators soon learned that Newman had disguised himself and carried out the act after weeks of planning. By early 2011, Newman was arrested. He admitted to what happened but claimed he was not in his right mind, saying he was suffering from mental illness. Prosecutors countered that the crime showed careful preparation, pointing to the rented vehicle, disguise, and timing. The case went to trial in 2012. After weeks of testimony, a jury found Newman guilty but mentally ill, and he was sentenced to life in prison without parole. Around the same time, Andrea Snyderman, Rusty's widow, faced her own charges. Though many of the most serious counts were later dropped, she was convicted of perjury and related offenses, receiving a 5-year sentence. Years later, Newman appealed, and in 2016, he was retried.
Ladies and gentlemen of the jury, I have been advised that you have reached the verdict. Who's the foreperson? Would you stand, please? Madam foreperson, has that verdict been reduced to writing and signed by you and dated as a foreperson?
Yes, Your Honor.
And is it written in ink?
Yes, Your Honor.
All right. Would you start at the top of the form and read it in its entirety into the record, please? Start at the top of the form.
In the Superior Court of DeKalb County, State of Georgia versus Hemi Z. Newman, defendant, indictment number 11CR1364-5, malice murder, possession of a firearm during commission of a felony, Judge Gregory A. Adams. Verdict: as to count 1, malice murder, we the jury find the defendant guilty. As to count 2, possession of a firearm during commission of a felony, we the jury find the defendant guilty.
Would you just read your juror number, please? You don't have to read your name.
This 23rd day of August, 2016, jury number 4.
Number 4. All right. Would you pass that to Deputy Moore, please? And once you pass it to Deputy Moore, you may be seated. Deputy Moore, would you present the verdict to the state, please? And they can review it as to form. Mr. James, any objection as to form?
No objection as to form from the state, Your Honor.
Thank you. Deputy Moore, would you present it to the defense lawyers, please? Mr. Land, any objection as to the form of the verdict?
No, not
all right. Lawyers, anything else for the jury at this time? And Deputy Moore, you may approach. Thank you. Yes, Mr. Land.
Judge, I would ask that the jury be polled.
Once again, the jury reached the same conclusion. He was guilty of malice murder. At the retrial sentencing, Rusty's family gave emotional statements describing the lasting pain for loved ones.
Mr. Newman, a jury has found you guilty of malice murder and possession of a firearm during commission of a felony. As a result, I just have a legal obligation to impose a sentence. I do not lecture individuals once sentences have been imposed, but as a result of the jury finding you guilty, as to count 1, malice murder, I will sentence you to life in prison. That will be life in prison without the possibility of parole. As to count 2, I will sentence you to 5 years to serve in prison, and that will be consecutive as to count 1. I will direct the sheriff to take you into custody at this point in time. You may take him into custody. Lawyers, you please step out of the way if you wish.
The The judge acknowledged the family's voices and imposed a firm sentence: life in prison without parole, plus 5 additional years for a firearms charge. With that, the long courtroom battle finally came to an end. In December 2011, New York City police officer Peter Fagosky was called to a home in Brooklyn after reports of a robbery. Inside the basement apartment, several men were attempting to rob a suspected drug dealer. One of those men was Lamont Pride, who carried a weapon. As police arrived, the suspects scrambled to get away. Pride hid in a boiler room, then tried to flee through a narrow stairwell. At that moment, Officer Fagosky came down the steps to intercept him. Pride had the weapon in his hand, and in the chaos, a single went off. Officer Fagosky, who had not even drawn his weapon, was struck and later passed away despite emergency efforts. Pride threw the weapon aside as he escaped, but was quickly captured. When his trial began in January 2013, Pride claimed the shooting was accidental, saying the weapon malfunctioned and discharged as he tried to run. Prosecutors, however, argued that he had loaded the weapon and was prepared to use it. They told the jury Pride faced a choice in that stairwell: surrender or to make his escape. They insisted the evidence showed he deliberately pulled the trigger.
When Lamont Pride fired the shot that killed Officer Fagosky, the shell casing got stuck in the mechanism. It was called stovepiping is the word they use, and he'll explain, this detective from ballistics, what that means and what the possible causes are. One of them could be the cheap ammunition that he had in the gun. But suffice to say that when the fatal shot that killed Fagosky was fired, instead of the shell casing being ejected, it got stuck in the gun mechanism. And as a result, this defendant could not, if he had wanted to, fire any additional rounds. The gun was in essence frozen. Now, I've told you about the eyewitness testimony, the police testimony, the video testimony, the DNA, the ballistics evidence, all the things you're going to hear from in the next couple weeks. But now, as I close, what I want you to do is think of this. I want you to put yourself, not, remember I told you, imagine you're Fagosky and Estrada arriving at the scene and this is all you know? Now I want you to put yourself in the defendant's point of view, okay? He is hiding in that boiler room, dark. He has seen the 2 first officers, Whirl and Gandini, enter the apartment, and now he sees his opportunity to escape. He sees his partner, Kevin Santos, break for the stairs and run out, and then he turns to run out. But as he does so, he's in this, now remember this little staircase. You come out of the basement, the floor is no bigger than one of these tiles. And it's 5 steps up to that concrete yard. And he comes up and he's got the gun. And remember, he had loaded it and drew the slide back and it was ready to go. And it's in his right hand. And he comes up, heading to escape, heading for freedom, heading up those stairs. And what he encounters is Pete Fagosky. Now you're going to hear from the medical examiner, Pete was only less than an inch taller than I am, shorter than I am, and admittedly I have a few pounds on him, but not that many more pounds on him. He was a big guy. And as Lamont Pride, and you can see his size, despite his height, he's a pretty bulky guy. He's got the gun in his right hand, he turns, and now we're in this tiny little basement staircase, concrete or cement on every side, and there's Pete Fagosky, almost my size, coming down in full uniform. He never even had a chance to draw his gun. Pete Fagosky's gun was sitting in his belt when he was not killed. But now the defendant is faced with really only 2 choices. He can submit to the authority of the uniformed officer and say, I'm under arrest, okay, you got me. Or he can use the 9mm semi-automatic handgun he has fully loaded and ready to go in his hand and shoot and kill Pete Fagosky in order to make his escape. And after you've heard all this evidence, ladies and gentlemen, it will be clear to you that despite his pleadings of this being an accident, this was no accident. He intended to kill Pete Fagosky because that was the only way he was going to make his escape.
Question that you should keep asking yourselves is, does this evidence establish an intent to a police officer? Now, we're not looking for sympathy. We're not here to make excuses. A tragedy occurred. But we're here to ask you to do the difficult job that you are asked to do and that you took an oath to do, which is to hold Mr. Taub to his burden, that he proves to you beyond a reasonable doubt that Mr. Pride intentionally killed Police Officer Vygotsky. And we submit that that was not his intent at that moment.
After weeks of testimony, the jury returned its verdict in February 2013. Pride was convicted of second-degree murder, aggravated manslaughter, and first-degree burglary, though he was acquitted of the most serious charge of intentional murder. Later that same month, the judge delivered a stern sentence: 45 years to life in prison. The punishment combined consecutive terms for the crimes, ensuring Pride would likely spend the rest of his life behind bars. In early 2018, Detroit police began noticing troubling cases on the city's east side. In February, the body of 57-year-old Annetta Nelson was discovered in a vacant house. DNA later linked D'Angelo Martin to that scene, though at the time, the case remained unsolved. The following year, the pattern became clearer. In March 2019, 52-year-old Nancy Harrison was found under similar circumstances in another abandoned home. Just weeks later, in May 2019, investigators made two more grim discoveries. First, Travisine Ellis, then Tamara Jones. All were women in their 50s, and all were found inside vacant houses. The similarities raised fears across Detroit that a serial predator was at work. Despite these concerns, Martin had not yet been charged in connection with the killings. During this same period, he was arrested on separate sexual assault charges, one in May 2019 and another in June after police found him at his grandmother's home. It wasn't until June 7th, 2019 that police arrested him at a bus stop after DNA evidence and a survivor's account connected him directly to multiple cases. During one of those hearings for cases related to assault charges, the court confirmed there were 9 potential witnesses, and a preliminary examination was set for July 16th.
Calling case number 1958054, not working by D'Angelo Martin. Defendant is charged with count 1, assault with intent to murder. Count 2, criminal conduct, first degree. Count 3, criminal conduct, first degree. Count 4, criminal conduct, first degree. Count 5, criminal conduct, first degree. Defendant is scheduled today for a probable cause conference. Appearances, please.
Good morning, Your Honor. William Lawrence on behalf of the people, P number 70481.
Good morning, Your Honor. Wyatt Harris, P54891 on behalf of D'Angelo Martin, who stands to my right.
Your name, sir? Counsel, today is the day set for probable cause conference. How are we proceeding?
Your Honor, Mr. Martin is demanding his exam, talk with the prosecutor and talk with the court. I think we have a date scheduled for that exam, which would be July the 16th.
Today is the day set for probable cause conference, sir. The court is going to continue your not guilty plea, continuing the matter to preliminary examination. With respect to the preliminary examination, Mr. Martin, you have a right to have a preliminary examination within 7 days of today's date. However, there's some kind of long scheduling conflicts with your lawyer and then the prosecutor's office. Are you waiving your right to have the exam within 7 days so that your lawyer can absolutely be present and be prepared to proceed?
Yes.
All right. The court is then going to set this exam as we discussed on July the 16th, 2019 at 9 o'clock a.m. With respect to the probable cause conference, the court notes that the people have listed 9 potential witnesses and the submission of
Possible medical records.
Possible medical records. This first one is not applicable though. Is that just, you may, let's say.
It's the form that I have, Judge. I'm in the homicide unit.
All right, so the just the possible medical records. Are there any stipulations at this time?
Not at this time.
All right. Are there any issues that the court should be aware of for the preliminary examination?
The prosecutor and I have been discussing discovery. The discovery is available. I will pick up the discovery today. There is one disc that is not available, but the prosecutor indicates to me that they should have the disc within.
By the end of the week is my understanding.
And I should get it from them.
So, counsel, is discovery available?
Yes.
Now?
Yep.
Okay. With the exception of the disc?
With the exception of one disc.
All right. Are there any other issues that the court should be aware of for the preliminary examination?
No, Your Honor.
Not on behalf of the defense.
All right, then we're all set.
By August 2020, a judge determined there was enough probable cause to move forward, binding Martin over for trial on 4 murder charges and 2 sexual assault charges.
Name, sir?
D'Angelo Martin.
What's your full name?
D'Angelo Kenneth Martin.
Okay. Mr. Martin, this is Magistrate Chanthea, 36th District Court. Sir, you have 4 criminal matters. I'm going to arraign you on each criminal matter. Do you understand that?
Yes.
I'm going to let you know the charges. I'll tell you the court dates, and I will tell you whatever bond there is. Do you understand that, sir?
Yes.
Okay. All right. First case is 190-60148, sir. It's allegedly occurred on February 26, 2018. Count 1. It is homicide, murder, first degree, premeditated. Maximum penalty, it is life without parole, DNA to be taken upon arrest. Count 2 is homicide, felony murder. Penalty, it is life without parole, DNA to be taken upon arrest. You have an habitual second offense notice. Penalty under the habitual, it is 1.5 times maximum sentence on primary offense or lesser term. Mr. Martin, do you understand the charges and penalties?
Yes.
Thank you, sir. I'm going to enter a plea of not guilty for you. You have court dates, which is going to be, October 2nd, 2019. It is probable cause conference, 8:30 in the morning, 36th District Court, to be followed by preliminary examination, October 9th, 1:30 in the afternoon. 36th District Court in front of Judge Bryant. Understand both court dates?
Yes.
Sir, you have a right to remain silent. Anything you say, orally or in writing, that can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights?
Yes.
All right, sir, because of the nature of the charges in this particular matter, there is not going to be a bond. You're going to be remanded to the county jail. Do you understand that?
Yes.
That's first case, sir. Second case is 190-60147, sir. Allegedly occurred on March 19, 2019. You are charged D'Angelo Kenneth Martin, count 1, homicide, murder, first degree, premeditated. The maximum penalty, it is life without parole, DNA to be taken upon arrest. Count 2, it is homicide, felony murder, sir. Maximum penalty, it is life without parole, DNA to be taken upon arrest. You have an habitual second offense notice. Penalty under the habitual, it is 1.5 times the maximum sentence, primary offense or lesser term. Mr. Martin, did you understand the charges and penalties?
Yes.
Thank you, sir. I'm going to enter a plea of not guilty for you. Court dates, October 2nd, 2019. It's probable cause conference, 8:30 in the morning, 36th District Court, to be followed by preliminary examination. October 9th, 2019, 1:30 in the afternoon, 36th District Court, again in front of Judge Bryant. You understand both dates?
Yes.
Thank you, sir. You have a right to remain silent. Anything you say, orally or in writing, it could be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Do you understand those rights, sir?
Yes.
Okay. Not only because of the nature of the charges, sir. This was in March 2019. The previous case was in February 2019. Sir, you're going to be remanded to the county jail, no bond. Do you understand that?
Yes.
Okay. Third case, 190-60146 against D'Angelo Kenneth Martin, allegedly occurred on May 24, 2019. Sir, you were charged with count 1, homicide, murder, first degree, premeditated. Maximum penalty, it is life without parole, DNA to be taken upon arrest. Count 2, sir, it is homicide, felony murder. Maximum penalty, it is life without parole, DNA to be taken upon arrest. You have an habitual second offense notice, sir. The penalty under the habitual, it is 1.5 times the maximum sentence on primary offense or lesser term. Do you understand the charges and penalties, sir?
Yes.
Thank you, sir. I'm going to enter a plea of not guilty. Same court dates, October 2nd, 2019. It's probable cause conference, 8:30 in the morning, 36th District Court, be followed by preliminary examination. October 9th, 2019, 1:30 in the afternoon, 36th District Court, again in front of Judge Bryant. Mr. Martin, you understand both dates?
Yes.
Thank you.
Court proceedings continued for the next 2 years. Then, in September 2022, Martin entered a plea agreement, admitting guilt to 4 counts of second-degree murder and 2 counts of rape. In October 2022, he was sentenced to a prison term of 45 to 70 years, bringing some measure of resolution to families who had waited years for justice. While his conviction provided closure, the case also raised difficult questions about missed opportunities and investigative delays that might have allowed the crimes to continue longer than they should have. In August 2023, police in Pocatello, Idaho, launched an investigation after a man reported that Jason Ernest Stark, a registered sex offender from Ogden, Utah, had abused him. The man also warned detectives that there could be other victims, which led investigators to take a closer look. As the case unfolded, more boys came forward. They described a similar pattern. Stark would befriend them, often by buying meals or small gifts, and then gradually draw them into inappropriate situations. Investigators recognized this as grooming, a calculated process designed to break down trust and create dependency. One detail highlighted in court was how Stark, a man in his 30s, would hang around malls and spend time with boys playing trading card games. Prosecutors said this behavior was not innocent. It was a method of gaining access to vulnerable boys. Over time, 6 victims were identified. In interviews and evaluations, Stark admitted to some misconduct but downplayed the extent, at first suggesting it involved only one boy. Later evidence, including a polygraph and multiple consistent accounts, indicated that the harm was broader than he admitted. Eventually, Stark was arrested and charged with several serious felonies. Multiple counts of soliciting a child for sexual abuse, lewd conduct with a minor, attempted exploitation of a child, and allowing a child to witness abuse. Prosecutors pointed out that Stark had prior convictions and argued that earlier supervision in the community had already failed.
This was a premeditated and substantial period of grooming that occurred. In a lot of ways, grooming, at least from the state's position, is at least as harmful and potentially more harmful than just a physical assault results in this sort of conduct. Because what he's doing is he's eroding their self-defense mechanisms. And at such a young age, he's almost preventing them from being fully formed in the first place. By gaining their trust and then using them to fulfill his own needs, the victims will not have the same mental processes as people who weren't subjected to this sort of behavior. And I think it's important to note that he did so under the guise of being their friend. He went to the mall as a man in his early to mid 30s and played Magic the Gathering with kids that were in. And he didn't do it because he wanted to spend time with them. He didn't do it because he wanted to make sure there was an adult there to be looking out for them. He did it so that he could take advantage of them. That's the same. That's almost the same thing as the proverbial van that says free candy on the side. That's the man that we're dealing with. things that I found most troubling when going through the materials, the psychosexual evaluation, PSI, is when he sits down with Dr. Hatzenbuehler, the very first time he says, well, I didn't really do anything. There were lewd comments I shouldn't have made. And then as the process goes on, there's a little, he says, well, okay, I touched him and I shouldn't have. Well, I just did it with the one. Throughout the psychosexual evaluation and the pre-sentence investigation, he is downplaying his actions and victim blame. He continued to maintain that his only contact offense involved the touching of one of his accusers on one occasion, and that the one sexual harmful contact with one of the 6 boys occurred 1.5 years after interaction with a group of boys. And then he takes it a step further and says, well, when one of the victims moved in with me and I had to kick him out, so I was getting married, then they all came after me, and that's why there's 6. Fine, all right, so that might account for 2 because they're brothers. But why would these other kids say that these things happened if they didn't? They have no motivation to do so. This is him deflecting, this is him downplaying, this is him not taking responsibility. He pled guilty to the 1 count, but I don't think he has fully internalized, probably because he doesn't have the tools to do so, exactly what it was he did and how harmful it was. He really, I would like to say that that's fixable, but he's already, I don't know anything about the laws from the state where this happened before, but I think it's safe to assume they have some similar mechanisms to what we have here, and they didn't work the first time. So that brings me to the 2 bill factors in Idaho Code 1925-21. As the court is aware, community supervision is supposed to be the go-to. None of the things under 1925-21 sub 1 apply. The defendant's criminal conduct neither caused nor threatened harm. We know it did. We just heard from one of the victims. The defendant did not contemplate that his criminal conduct would cause or threaten harm. He spent years grooming these kids. He knew it was going to cause harm. He just didn't care.
In March 2025, Stark entered into a plea deal. He pleaded guilty to 2 felony counts, lewd conduct and injury to a child, while the other charges were dismissed. The agreement recommended a sentence of 10 years, fixed plus 20 years, indeterminate, for a total of 30 years in prison. At sentencing, District Judge Cody Brower made it clear he felt the plea agreement was lenient compared to the damage caused.
Other than the ones we've discussed of your accusers, have you had hands-on contact with any others? Significant reaction. Other than your accusers, have you ever received, to your advice, pictures of any of those boys? Significant reaction. Now I know that polygraphs aren't infallible, but I also recognize that we use those as an indication of risk. I find you to be a great risk to this community. I find that you harmed those. I find that you did so without consideration of what it would do to them. I find that you are deserving of punishment, and that this court must enter a sentence that will protect society. That's a great reason why I accepted this plea agreement. It's the reason I did not back off of it after reading this information. Because this plea agreement at least guarantees that you will be incarcerated for the next 10 years, as you deserve. And potentially for another 20 after that. I don't find either, oh, I guess I do find, I don't think you've taken accountability. Not entirely for the conduct that you committed. I agree with Mr. Taylor. I have a hard time believing that 6 young men would come out and put themselves through this, potentially put themselves through a trial. The shame and the hardship that these things incur, simply because they wanted to get back at you because one of them was kicked out of the house. That simply does not compute. Another one because the other one you stated because he had disclosed things to a treatment counselor, that must be the reason. That does not make sense. I don't believe it makes sense. I've reviewed this information. I find their statements to be credible. And here, you have admitted to committing a lewd act on one of these children, to soliciting other acts at a minimum. And you even said here in your polygraph that had you been provided the opportunity, you would have taken it. You are a risk to this community. And quite frankly, how dare you commit this kind of conduct on young teens. I do impose on you in count 1 a 10-year fixed, 20-year indeterminate sentence for a total unified sentence of 30 years. I'm going to impose that sentence. I will grant you 449 days time served as set forth by statute and required by statute and the plea agreement. I'm going to run that concurrent with count 2. I'm going to impose a fine in this case that is indicative of your conduct. I have considered this amount, whether you'll be able to pay back this amount. I consider your age and your employability after incarceration, and I find that this fine is appropriate given the circumstances and those 4 factors. So I will impose a fine of $10,000. I'm going to impose court costs as set forth by statute. I'm also going to impose a $5,000 fine pursuant to Idaho Code 19-5307, which shall act as a civil judgment against yourself and entered on behalf of PN. The court issues this, or will issue this as a separate order, imposing this fine on behalf of the victim. This fine is ordered solely as a punitive measure against the defendant and is not based on any requirement of showing of need by the victim, and it is unauthorized under subsection 2 of that section. In count 2, I will impose 10 years fixed, 0 years indeterminate. I will impose that sentence and run it concurrent with count 1, and I will grant you time served. I will also, in that count, impose a fine of $10,000. I will impose court costs as set forth by statute. I'm also going to impose a fine of $5,000 under 19-5307, which shall also act as a civil judgment against yourself and will be entered on behalf of EB, KL, GN, KN, and JC, with $1,000 being apportioned to each of those victims, as the statute limits the fine and that charge to $5,000. Elsewise, I would probably enter more. Court will also issue, again, a separate order imposing that fine on behalf of those victims. The fine is ordered solely as a punitive measure against you. It is not based on any requirement of showing of need by those victims and is authorized under subsection 2 of that section. Mr. Stark, I've entered this sentence against you within the bounds of that plea agreement for the reasons I've stated. Someday you'll see the light of day again after you're released from the Department of Corrections. Do not consider ever taking this action again. There need not be another victim that have gone through what these victims have gone through because of your actions.
Ultimately, the judge accepted the binding plea deal. Stark was sentenced to 30 years in prison with a $20,000 fine and an additional $5,000 civil judgment to be shared among the victims. The judge emphasized that while Stark had not fully taken responsibility, the sentence at least ensured he would remain behind bars for decades, keeping the community safe. As the hearing concluded, the court commended the courage of the victims for stepping forward after years of silence. Stark was then remanded to the Department of Corrections, where he will begin serving his sentence. On Mother's Day in May 2020, Jessica Bedford, a 24-year-old mother from Detroit, called her mom to say, "I love you. Happy Mother's Day." That would be the last time her family ever heard from her. By the end of the month, when she still hadn't returned, her disappearance was officially reported. Jessica's daughter has since been raised by her grandmother, while her case remained unsolved for nearly 5 years. In April 2025, investigators announced a major development. 31-year-old Yvonne Deshawn Clark was arrested and charged in connection with Jessica's disappearance. Prosecutors allege that Clark was responsible for her death, though her body has never been recovered. Along with first-degree murder, he faced additional charges related to firearms and the handling of remains.
Your Honor, the people are going to be asking for a remand in this case. The defendant is charged with first-degree premeditated murder and mutilation of a corpse. The facts of this case are fairly gruesome. The defendant shot and killed a young woman and disposed of her body. Her body still at this point has not been found. The defendant has a criminal record. He has using a computer to commit a crime. He also had a reckless driving causing serious body impairment. He also has a contact for 2017 for an assault with intent to murder, which was dismissed at trial because the witnesses have failed to appear. But I would like to let the court know we will be resurrecting that case. And when they arrested him, it appeared that he was operating a chop shop out of his backyard, and they're going to be investigating that case and potentially submitting a warrant on that case also. For those reasons, Your Honor, due to the nature of the pending charges, I think a remand is in order.
Did I lose the court?
No, I can hear you. Go ahead.
All right, thank you, Judge. Respectfully, Your Honor, I'd ask the court to grant reasonable bond pursuant to 6.106, and that governs the pretrial release. Judge, this is a cold homicide allegation. It stems from a missing person report of 2020, and as Ms. Lindsay has indicated, the body has never been found, so that leads us to believe that the very foundation of the criminal charge is in question. That's the corpus delicti rule. The evidence in this case is going to be very weak. It's based off of informants or people who don't have much credibility in terms of how this happened. They don't have any forensic data from my understanding or evidence, and there's no body, and I don't know about these eyewitnesses either. Mr. Clark has substantial ties to the community. He has a long standing connection to this jurisdiction. He has family here. He's employed. He owns a trucking company where he also owns property as well in the city of Detroit. He's lived here for decades. And despite knowing about this cold case investigation for years and being a suspect of it, he hasn't fled the jurisdiction. His criminal history does tie from a reckless driving causing serious injury. Ms. Lindsay has referenced uncharged cases, and I don't think the court should give any weight to cases that haven't been charged and cases that have been dismissed. And he has another case involving a computer, which was a felony. The severity of this current offense is the most extreme. It's severe. But the severity alone is not dispositive, Your Honor. So we look at the weight of the evidence. It's extraordinarily weak in this case. The lack of the body undermines both the probable cause and a likelihood and conviction in this case, which should favor some reasonable bond. I don't think that he poses a flight risk, as a result of him being engaged in this community, not fleeing the jurisdiction despite knowing for a number of years that he was the target of an investigation involving a homicide. And it's important to note that this case has sat dormant for years. The witnesses in this case were interviewed in 2021, and the case was only brought now. And so that should lead to some of the question mark as to what's going on with this case and where the underlying facts are. But I do believe that this court can set some reasonable conditions, and whether it be a high cash bond or a bond, with a GPS tether, we wouldn't have an objection to that, Your Honor.
Your Honor, the defendant's hubris in thinking that he got away with a murder, and his hubris in thinking that he had successfully intimidated witnesses not to come forward is no reason to reward him. As to counsel's allegations that the case is weak, seeing as how he has not reviewed a single bit of discovery in this case, that is baseless. We do have some evidence in the form of, for lack of a better word, GPS tracking and things of that nature that support the statements of the witnesses. For those reasons, Your Honor, I'm going to ask the court this is a first read, and in cases where the proof is evident and the presumption of guilt, a remand is in order, I'm going to ask for a remand at this point.
All right, the court haven't heard argument as to bond in this matter. First, I want to address two issues. First, Mr. Macklin, you alluded to the fact that due to the time it takes for the charging and that the body has not been found. Typically, cases oftentimes take years to investigate, as you well know. This is not CSI or television crime dramas where they're solved in a half hour or an hour. And so oftentimes they get leads, there's DNA oftentimes. And so it's not uncommon for homicide cases to take years. And to your also point, Mr. Macklin, the court will not take into consideration any charges that have not been filed against your client. So the court would not factor that into the bond consideration. All right, now as far as you, Ms. Lindsay, it is well noted that there's circumstantial evidence, and I believe there is a presumption of guilt in this matter, notwithstanding that a body has not been found. I think it's conjecture on your part, Ms. Lindsay, to claim that it was hubris on his part. And I don't know, because the court doesn't have any facts to that he's intimidated witnesses or anything. I would not take that into consideration of bond in determining a bond. I think that's all conjecture at this point because there's been no evidence to the court with respect to that claim. But nonetheless, the allegations are very, very serious. This is a circumstantial case. I believe it's a relatively strong circumstantial case. And under MCR 6.106, I will remand Mr. Clark into custody of Wayne County Jail while his case is pending.
During his arraignment, the prosecution pushed for Clark to remain in jail without bond, citing the seriousness of the charges and his past record. The defense, however, argued that the case was weak, pointing out the lack of forensic evidence and stressing Clark's longtime ties to Detroit, where he owns property and a business. After reviewing both sides, the judge ruled that Clark would stay in custody while the case moved forward. In August 2025, the preliminary hearing brought the first detailed testimony. A longtime friend of Clark told the court about a late-night visit in 2020, when Clark appeared distressed and hinted he had done something terrible. The witness also recalled being asked to help move something from a basement, but admitted he never actually saw anything himself. Prosecutors presented this as important circumstantial evidence, while the defense maintained it was unreliable. The case is now proceeding toward trial, nearly 5 years after Jessica Bedford vanished, as her family continues to wait for answers. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.